there's some ambiguity here as to whether that individual was really terminated properly or not. So, as a compromise, the $800 is paid to the JTC and found the contractor not in violation of the contract. That's fine, right?
No.
All right, everyone, we're back again for another recording of the Labor Thoughts podcast. Jef is becoming a regular guest. I guess if this were a TV show, you're getting ready to move from guest star to I guess main cast, and we'll have to start discussing first build and last build and all that fun stuff.
I might have to join the SAG or something.
Fun fact: we do have a chapter manager, at least one that I know of, that is a member. If you're listening, you know who you are.
The cereal guy?
Yeah. That's why I've got to figure out how to bring him on as a guest. It's a whole stack of contracts, everything like that I got to go through. But we've got Jef with us again here today. For those of you that don't know, and I'm not sure how you don't know, but Jef is our Senior Vice President of Labor Relations and Risk Management with NECA. He's also got the designation of General Counsel. So I usually lean on him, especially in that second one, but also as being my supervisor and somebody I go to for advice quite regularly, both from a legal perspective and just for general advice. I figured you'd be a good one to bring on for this topic. And for those of you that were looking, the title is Don't Get Punitive today. So Jef and I are going to try to keep it professional and not take too many shots at each other. But let's dive into that a little bit. In the labor management relationship, we have we have our collective bargaining agreement. We have a dispute resolution process, and if everything goes right, we ultimately render a decision. And those decisions can potentially get into some areas of issue, one of which could be punitive damages. But before we unpack that, probably a definition is in order. So, Jef, what are punitive damages?
So punitive damages are damages that are designed to punish or persuade behavior in a certain way. So they're actually extra contractual damages. So they grew up originally in criminal law and then expanded to what's called tort law. So tort law is law that provides consequences for poor behavior that doesn't rise to the criminal level, right? So negligence, reckless behavior, intentional misconduct, interference with contracts, interference with other rights. Those are all torts. And tort law, sometimes by statute, sometimes by common law, provides opportunities in certain situations for punitive damages to prevent the bad behavior the next time, or serve as some sort of penalty that is beyond a make whole or restitution situation. The same with criminal law. The courts over the years have injected penalties and fines into the criminal process that go beyond restitution. So, for example, if someone were to burglarize your house and take $5,000 worth of goods from your house, one thing the court might do in a case, a criminal case, is to provide you with restitution as the victim, right? So you'd get your $5,000 back. But the court would also and could also impose, fines and penalties on that defendant to deter future criminal behavior. So that's kind of how punitive damages grew up, and most of the time punitive damages are provided by statute, And there are various caps. For example, like medical malpractice has a punitive damages cap. Title VII discrimination cases have a cap on punitive damages and the like. So that's probably a little longer than you wanted, but that's what punitive damages are.
No, I was staying quiet because I always love getting into the legal aspect of it. I like to learn as much as I can there, and I learn listening to that. So, I always want that information, but do want to dig into it a little bit. I know this isn't necessarily applicable to our industry, but you just kind of sparked some curiosity in me. So, under this tort law or wherever you're in, essentially maybe even a non-criminal setting, but there are, like you said, there's caps to punitive damages, whether it was medical malpractice, negligence, things like that. Is there a process in determining, I guess, what that amount or what the damages are leading up to the cap? If they're going to be under it, how do they determine where you kind of fall in that scale?
Are you asking me how the cap is originally determined, or who makes the decision as to, where under that cap a damage award would fall?
I think probably yes, but probably the second one first.
So the caps are, a product of legislation. So, you have the plaintiffs bar, the people who sue people. They want no caps or high caps. And then you have the defense bar, or the people who represent employers and companies that get sued. And they want, either no punitive damages or low caps, right? So, I don't know all the history, but the easiest cap that comes to mind is medical malpractice, because, if you're talking about someone who, let's say, died as a result of medical negligence, how do you put a cap on that award? It could be a runaway. You could have a 25-year-old father of 3 who dies on the operating table, and how do you provide an adequate award to that family? You could have a jury that could say, well, I think that's $20 million. Well, after you get done with future earnings and what would be restitution, there's got to be some rational limit on what would be punitive, right? And that would be, the punitive part of it would be beyond the restitution, the make whole remedy, right? Mm-hmm. So if you don't have that cap, you're just going to have these runaway verdicts, and we see that some in the big trucking auto accidents and things like that. We'll see some runaway verdicts, and you've probably seen where a jury is awarded X and the court has remitted that award down to the cap, right? So, jury awards 85 million, court reduces it to 2.8 million. And you think, well, why did they do that? Well, because there's a cap on the non-make whole remedy, which would be the punitives.
But the whole award is essentially a sum of the make whole plus the punitive. So that's
correct, if punitives are permitted, right?
Okay. So it's the make whole where we have to spend a good bit of our time here in our industry. When you have a grievance that comes up and you have an individual that's making some form of claim, we have limits of what we can do as an arbitration body. Jef, do you want to kind of touch on those a little bit of what the limits are of an arbitration body? Yeah, so
I'll start with the basic premise that typically in contract law and in contracts there are no punitive damages, right? So when you have an arm's length agreement like a collective bargaining agreement, or a contract for rendering services, unless in that contract there's a penalty provision or a section on penalties, the idea of suing under that contract is really to prove damage, prove your loss, and then have the right to be made whole under that contract. And there are all kinds of provisions in non-collective bargaining agreements that impose limitations of liability and the like. But just for our purposes, our collective bargaining agreements don't contemplate punitive damages. Our labor management process is designed to adjudicate grievances that spring from the contract and enforce contractual rights. And one of those contractual rights, implied in the contract, is to be made whole for any loss that's associated to the contract. And we can go over some appropriate claims, some appropriate grievances that would have monetary, restitution, so to speak, or make whole remedies that would be proper, under labor management. If you want to go through some examples, we can do that. But slapping someone with a request for a penalty, or a donation to a fund, or some other cause or something like that is really not proper in our labor management process. And I'm sure you're going to get into this, but there are some unintended consequences to thinking that that's a good idea.
Well, you opened the door, so I'm gonna walk through it here for some examples. So a typical grievance that we would see is the individual is terminated for cause, and they grieve, say that it wasn't proper cause, and a request typically from the union will be for X amount of hours, and it's kind of a clock that's running of wages paid to the individual until either they're rehired or something along those lines. Let's say we hear this grievance and all the information comes out. As typical, it's muddy. And the decision that the labor management committee decides to make is this individual realistically missed out on 20 hours of employment. And when you work that math out for wages and benefits, it comes to, I don't know, I'm going to say $800. However that works out. But there's some ambiguity here as to whether that individual was really terminated properly or not. So as a compromise, the $800 is paid to the JATC, and found the contractor not in violation of the contract. That's fine, right?
No.
Care to elaborate?
Sure. So that's not a make whole remedy. That is a finding that is at odds with the imposed sanction or remedy, right? So if you find no contractual violation because you can't make up your mind, but you kind of quote unquote split the baby by saying, we're going to make you pay what you would have owed anyway, but we'll just have you send it somewhere else. You really don't have jurisdiction to do that, within the confines of labor management. Labor management is adjudicate rights under the contract, impose a make whole remedy, or some sort of restitution for the contractual violation, or don't find the contractual violation, right? But you shouldn't be fashioning this, sort of no finding, but we're going to make you pay something so that everyone walks away happy type of situation.
Sounds more like a negotiation as opposed to a grievance adjudication.
Right, and that's not the appropriate place. There's no place for that in labor management, in my opinion.
Yeah, it's violation or no violation. So I guess expanding on that a little bit, and a best practice standpoint, would you recommend labor management committees that issue no violation? Would your recommendation be that that's where the sentence stops?
Correct. I mean, if there's no contractual violation, then there's no appropriate remedy.
Yeah, because then what are you making whole, right?
Correct.
Yeah. Let's talk about a different one then. So the contractor was found in violation, but instead of compensating the individual, in this case, the grievance is not necessarily over an individual being terminated. The violation was that the contractor violated referral in some way. They didn't follow the process as they should. So the Labor Management Committee met, and they determined that had the contractor followed referral, then, let's say Bill would have been employed because they were the next person on the book, and they would have, had the availability of 30 hours, for however long the potential job would have been. In that case, is the Labor Management Committee afforded the ability to find the contractor in violation of referral and then direct payment of wages to an individual on the referral list that should have been eligible for employment?
Well, that person is not an employee, right?
Right.
And so the CBA is designed to protect employees. And so now we're going to pay somebody that's not an employee?
I designed it that way. I was curious if you would hesitate the way we do.
I don't like that result.
Yeah.
Because now we're giving, quote unquote wages to, back wages or lost wages to someone who's not an employee of the organization. So in my opinion, labor management is designed to adjudicate the rights between an employer and an employee, both bound by the CBA.
And I didn't mean to just spring that one on you, but I wanted to kind of show how uncomfortable that can make an attorney of trying to push money or pay wages to somebody that's not an employee. We talk about it a lot as, from the labor relations perspective of how you need to avoid things like that. But I kind of wanted to put Jef on the spot there a little bit and just show that that's just not an area you want to venture into. So what is the proper way? The contractor has legitimately been found to be in violation of the referral procedure. What would you consider to be a legitimate remedy for a contractor that has violated referral?
A directive to not violate referral.
Yeah, remind them of the process. This is how it works. Yeah.
And, I suppose if the union was proffering potential candidate X as the properly referred candidate, then maybe there's a directive that should be your next hire. That would be fine. But I wouldn't provide back wages to someone who wasn't an employee when the grievance was filed.
Yeah, that is a practice that does tend to pop up quite a bit. I can say there's probably more than a handful of those decisions out there. But, let's say that did happen. They do pay, or that there is a directive to that employer to pay wages to somebody that's not an employee. What are some of the liabilities or risks that are now involved there?
Well, again, I don't think that's proper I don't think labor management has jurisdiction to do that. So I think it degrades the labor management process to use it in a way that frankly is not enforceable. If I were an employer and I didn't want to pay that, I'd have to figure out how to challenge it. But you would have a remedy in the courts as well. because it's really outside of the labor management process that remedy was fashioned. So, I also have a problem with giving what purports to be wages to someone who is not an employee, right? So it affords them, monies as if they were an employee when they're not. So I think that would open the employer up potentially to a claim that, now you've sort of made me an employee for this period of time that you're paying me. And I wouldn't want to do that either.
Well, shameless plug here. If you want to hear more on some liabilities that you as an employer can open yourself up to in that employment process, there may or may not be a Labor Thoughts called You're Hired, where Jef and I actually get into that discussion. So definitely check that one out. Jef, I appreciate you being a champ on fielding those questions there. Those can be awkward, and they're kind of common practice in our area, but it's definitely opening up the labor management process to challenge, like you said. We're definitely not here to tell employers to go challenge a labor management decision. It is a contract you signed. It is one that you have agreed to abide by. But the words of caution, I think, that Jef's trying to get across, and that I would definitely echo to those that are on a labor management committee is to be sure you're rendering decisions that are enforceable. Because I like Jeff's term, you degrade the labor management process. This is a respectable process. This language and these agreements have been around for a long time. We should continue to support that and support resolutions that can be defended. So I think that's a lot there. And Jeff, you did kind of hit on it there, is the risk of rendering a decision that's punitive. Just essentially opens it up to challenge and not being enforced. Just, I guess, off the top of your head, do you have any other kind of punitive awards you think would be out there that you could see coming out of the labor management process?
Well, what I've seen directly in my time at NECA has been, decisions where, there's been a finding of a violation of the contract. There's been a make-whole remedy that is designed to protect the employee that's at issue. And then there's a side deal for, a donation to the local LMCC or a charity or something like that to gain an agreement during labor management. And that it's just, and it's seemingly harmless, it's seemingly innocuous, make a $500 or a $1,500, $10,000 donation to make this all go away. And, that becomes habit forming, right? And it's not the purview of labor management to stick employers with that kind of damage or penalty, and I'm not a fan of it.
Yeah, I think what it boils down to is if you can't calculate it in the contract, you can't award it, right?
Right.
So, I mean, there could be some instances where you could potentially go beyond that if there was, property damage, something like that. But again, that's something that you could see, you could calculate. You could say, this is the make whole, this is the restitution portion of it, and that doesn't necessarily venture into the legal area. But that's kind of the parting advice on this is if you can't find a vehicle for it in your contract, you can't really award it. And that's applicable everywhere from labor management to CIR,
Yeah, the way I would phrase it is, you need to be able to come to labor management with the argument of, I'm entitled to this under the contract because, it is set out here, or it's subsumed within my rights to X, lost time, overtime, wages, back pay, waiting time, holiday pay, those kinds of things are all subsumed within the contract and the contractual rights. If we start making awards to, deter bad behavior or future behavior or punish someone because they made a certain decision, you're getting outside of the labor management process. There are extra contractual damages that the parties didn't bargain for and shouldn't bargain for. And it's a slippery slope. Like I said, it leads to unenforceable decisions that, frankly, not to be offensive to anyone, is a little bit lazy. It's because it's a way to say, all right, I'm gonna make this go away. I throw a little bit of money at it. I'm gonna make this go away, and we'll worry about the next one next time. That's not the best practice, I don't think.
Yeah. Unfortunately, it's easy to do, but it could cause you problems down the road. All right. Well, Jeff, this is going to be probably one of our shorter episodes because it needs to be. This topic, it's pretty simple. You when you're conducting a labor management meeting, you have what you can do within the contract. Like you said, did I violate the contract? If I did, what's afforded to the individual according to the contract? Anything above and beyond is punitive and unenforceable. But of the stuff, all the items we talked about today, for our listeners, our viewers, like these are the things you absolutely need to take with you, or just your parting words to them on this topic, what would that be?
Yeah, I just think that, the labor management process is so important that, unintended consequences in a particular case need to be minded, and like I said, if you get into a situation where, you think you're not going to resolve it, but if we just put a little bit of money on the table, if that money can't be found in the contract somewhere, and that's not remedying something in the contract from a contractual violation, then it shouldn't be awarded, because, to be honest, the labor management process just doesn't have jurisdiction to consider that. Certainly doesn't have jurisdiction to award it, and I just think it detracts from the proper purpose of labor management, which is to adjudicate legitimate disputes under the CBA.
Yeah, uphold the contract. Yeah. So, and that's something to take away from this is, I've been a chapter manager. I've been in these situations, and it's difficult. It's hard, especially if there have been past decisions like that, and there tends to be a leniency or a tendency towards them. The best response, the best combat to it is, do we really want to issue something that can't be enforced? It's going to degrade the process. It's going to, I guess make it look almost like a joke. And I hate to say it that way, but that's potentially what it could become. And I don't mean to be that harsh, but I believe in the process. I believe in the dispute resolution process. And, you should be abiding by it and awarding what is available under the contract. Jef, thank you for your time today. I appreciate you coming on and talking about this one. We get these questions a lot, and I can almost guarantee that when this publishes, we're probably going to get quite a few more. So obviously, contractors, if you have questions on this, start with your chapter manager. They'll be able to field a lot of them. Chapter managers, use your field reps. They know how to get a hold of us. We'd be happy to talk to any of you guys on this subject more in depth. If there's any questions you have about anything else we've talked about, obviously send it our way. There's a topic you guys want us to cover, if you're interested in being a guest on the podcast, even if you are a member of the Screen Actors Guild, I'm not going to discriminate, because I also know that's wrong. Please come on the podcast, and we'd love to talk to you. We'd love to get into these types of discussions and provide useful content for our chapters and our members. So thank you for listening. Thank you for tuning in, and we'll see you on the next one.